Hey, good morning and afternoon to everyone that joined us today. Thank you for attending. Um, this is the Denton's Labor Spotlight Series. And you've hopefully attended before, and you know that this is a webinar dedicated specifically to issues in unionized workplaces that employers will face. And we're also trying to get to down and dealing with the in the trenches topics, the more practical issues and day-to-day topics that we deal with as labor relations specialists. And so we're not focused on, the leading, most recent Supreme Court decision. Frankly, there aren't a lot of those in labor relations, but we're more focused on practical day-to-day skills with this webinar. So it's a little different than the normal offering, I think. All right, so let's get into our first topic. It's KVP and the art of introducing new policies. So KVP is a term you may have heard. And we'll talk about it in a minute. It's just the name of a case. So there's no mystery to that. So we'll talk a bit about the case and look at some examples. So let's look at the next slide. So when you're introducing a new policy, it's really just an exercise of your management rights, right? And your collective agreement likely has a management right clause. They're usually very broadly written. The right to manage the workforce, assign duties, set schedules, that sort of thing. And the main thing to remember is the collective agreement really exists to limit your rights as employers. So everything in the collective agreement is a limit. Where it's not covered by the collective agreement, you generally have the right to do it. Now, there are some restrictions beyond that. They can form or come from past practice. So if you've done the same thing for years and years and you suddenly want to change it, the union might say, well, you're stopped, it's a legal term, from making that change until we get a chance to bargain this. So during this term of the collective agreement, you can't make that change. And like I said, there's actually one of these webinars dedicated totally to that topic. It's complicated, so feel free to go watch that. But so that's one example of another restriction on the exercise of management rights. And of course, statute is a restriction. So all of the statutes, the employment statutes like the Employment Standards Act, or any human rights legislation or workers' comp legislation is also sort of incorporated by reference into the collective agreement. So after that, though, what are the limits on our rights to exercise our management authority in the workplace to get everything running and to run the business? And arbitrators struggled with this for a few years before they came up with this next case. Let's get the slide here. Lumber and Sawmill Workers Union and KVP. So everyone calls this the KVP test. So you might hear your counsel talk about this or the union talk about KVP. And this is what the case is. It's actually a very strange case. It's from 1965, which is sort of the start of a lot of this labor jurisprudence. So it's sort of in the early years of all of this law being developed. And it's actually about this company, KVP company, which I guess ran a sawmill. They were very upset that employees were, I guess, lapsing on their debts outside of the workplace, and there were creditors going after their employees, and there were garnishment orders being issued, and the people seeking the garnishment orders enforcement were coming to the employer and saying, garnish this paycheck, garnish that paycheck, and the company, for whatever reason, created this semi-random rule that if you have any more than 3 garnishees, you're going to get fired. So it's pretty strange. I think some of these early cases are sometimes funny in that way. And strange cases often lead to strange law. So this case created the seminal decision. Those facts created the seminal decision and created this framework. And basically that's the use of it, is the arbitrator set up this framework of 6 points. I'll go over them now, that an employer has to think about when they're rolling out a new policy in the workplace. So the first one is probably pretty obvious. The new policy can't be inconsistent with the collective agreement. So that's kind of obvious, right? Like you bargain a collective agreement, you can't impose a policy that's contrary to it. So that's obvious, right? Although I guess sometimes it's not clear on its face and it might be inconsistent. So number 2 is actually the most important one of all of these, of the 6. And it's one we're going to talk about for the rest of the presentation. So it must not otherwise be unreasonable. So that question of what's reasonable is going to be different in every case. And a lot of times, as you'll see, it goes to the question of employee privacy, but it's not necessarily always about that. It's whether or not looking at the totality of circumstances, so it's going to be very fact specific. A subjective person would find that the introduction of the policy, sorry, an objective person would find the introduction of the policy was reasonable. So it's not whether or not one union person thought it was unreasonable or one manager thought it was reasonable for him or her. It's going to be an objective standard. Okay. So that's, like I said, where the rubber really hits the road. The rest are really pretty obvious. So number 3, it must be clear and unequivocal. If you're going to roll out a policy, people need to understand it if they're going to comply or be expected to comply. Number 4, it must be brought to the attention of the employees. Once again, pretty obvious. Number 5, it must be introduced with notice that a breach could result in discipline or whatever the ramification of a breach would be. So that goes with number 4. Employees must be aware of the impact of them ignoring this new policy. And number 6, it must be consistently enforced. Just like always, whenever we have inconsistent enforcement of any of our rules, the union can look back and when we try and enforce it, they can say, oh, look, in the past, you've let us get away with this. And they can make all sort of hay out of that sort of argument. So we have to be very consistent. So we take that argument away. So like I said, most of these are obvious, except for number 2. And that's really what the test is about, the reasonableness of the policy, okay? In most cases. And so there's a few applications. And like I said, it often intersects with privacy because privacy and reasonableness, we have a webinar on that too. Those two topics are very tightly intertwined. There's not a lot of black and white rules around privacy. It all goes to what reasonable expectations are of employees of privacy in the workplace. So in this case, the employer introduced an electronic monitoring policy, ostensibly to meet the requirements of the Working for Workers Act, where all employers are required to have a policy. Now, the reality is that act didn't require any specific content in the policy, so it's not, it probably wasn't something that the employer could rely on. The statute didn't require them to set out the content, just to have a policy. So that policy provided that the employer could monitor all emails sent via the employee's network. So that included if you pulled up your phone and you were on Wi-Fi and you sent an email on your Gmail account, the employer would monitor that. All records of phone calls and text messages that were client-based, and all network and computer activity. So all of that was going to be monitored under this new policy. So the union grieved it. The next slide. And the arbitrator found that it was a reasonable exercise of management rights to view emails, with the exception of the personal emails. Obviously, the employer's interests did not extend to the employee's personal emails on their personal devices over the network. So the arbitrator found that it was reasonable to have business emails monitored. Same thing with text and phone calls. Management had a strong interest in monitoring client calls and taking records of those. And an employee's expectation of privacy with respect to those sorts of calls was low. And then the network monitoring was not found to be reasonable because employees were permitted to use their own devices. And the arbitrator found that that was an unreasonable intrusion into employee privacy. So as you can see from this, the actual case isn't so important, but they really get into the nitty-gritty of the specific application of the rule. Let's look at the next slide. So this is another privacy case, but totally different context, right? So this is about drug testing in the workplace. Irving and Pulp and Paper Limited is one of the seminal cases about drug testing in the workplace. We have a webinar about that as well. So, but in this case, it was another paper mill, actually. They were rolling out random alcohol testing in the workplace because they believed it was a safety-sensitive workplace. It was. And they thought that that was a reasonable exercise of their authority to ensure that the workplace was safe. And they would have argued that it's their obligation as an employer to ensure a safe workplace. So they had, this was a reasonable step to enforce this randomized testing. So An arbitrator disagreed with the employer and found that it was too intrusive on employee privacy, and specifically that the balancing wasn't there, that there wasn't a clear problem demonstrated by the employer of a workplace drug or alcohol problem that would necessitate such an intrusion. Okay, and it went up to the Supreme Court, and the Supreme Court agreed with the arbitrator. Next case. And agreed that there needs to be more than just a safety sensitive environment to authorize that sort of level of employer intrusion. So it wasn't reasonable. Now, interesting thing about this, the law is always changing on this specific topic. Well, all topics, but one thing we're looking at this for the KVP principles, not specifically for drug and alcohol testing, but in the last year, or so I guess it was in January of 2025, the Federal Court of Appeal introduced a decision and that found that in the nuclear context, employers didn't have to wait for an accident or wait for a whole bunch of evidence that people were intoxicated in the workplace before they could roll out randomized testing, because the safety sensitive workplace was such an important thing, and there was a reduced expectation of privacy for employees working in that environment. So the law is always moving, but the important thing is remembering that that standard is always going to be reasonableness in the context of the workplace. So let's look at the next slide. So there's a few more examples here. This is a Hamburg hospital case, recent case about vaccine mandates. So it took a little bit of time for the vaccine mandate cases to go through the process of arbitration. And in this case, the arbitrator upheld the employer's mandatory COVID vaccine policy. Once again, consider that reasonableness question and a balancing of interest between employee rights to not be vaccinated or to attend work without being vaccinated, and the employer's interest in ensuring that it was protecting its workers and its patients. Great. Let's go to the next slide. Here's an example, another example, absenteeism. So a lot of employers introduced an absenteeism problem. So this one doesn't really overlap with employee privacy. So it shows the KVP isn't just about that. In this case, the policy required employees to provide a medical note for any sick days beyond 6 days. And presumably at the time, the 6 days, oh, this is in Newfoundland, the 6 days might have been a statutory protection that they were able to access. And so anything beyond that, the employer was asking for a medical note. And the grievance was denied, and the policy was upheld by the arbitrator, who found that the goal of reducing absenteeism through the policy was a reasonable one. It wasn't contrary to the CPA, and it was clear and unequivocal. Employees were provided notice. All the other aspects of the test were met. Okay, great. So let's look at this next slide. This is a scenario. So just to get a little audience participation here, let's consider this. And then if you have any thoughts, put them in the Q&A section of the chat, whatever you can access. And I'll ask some questions maybe at the end. So you've been advised that the company's headquarters, which is located in Europe, is concerned about shrinkage in the company's global warehouse. And no, they didn't just watch a Seinfeld rerun. Sorry, I had to put that joke in there. They noted significant losses in their warehouse in France. All global branches have been advised to implement an airport-style metal detector and pat-down program at the exits of the warehouses. Failure to comply will result in poor annual audits and could affect whether the plant stays open or management bonuses at the end of the year. So does anyone want to weigh in on what concerns are triggered by this? Let's see. Anyone have any thoughts? If you get this direction and you're an HR person, what are you worried about? Okay, so someone says there's no evidence that the local plant has an issue. That's great. Yeah, that's a really good point. The scenario, it's too broad to cover all locations. Deal with specific locations with the issue first. That's a great point. Privacy, why is the pat down required? Could we not use a less invasive method? Yeah, that's really good. So that goes to reasonableness too. So, right. So I think the big issue here is employee privacy and the invasion of privacy with the pat downs, right? So there's going to be a balancing. Um, and in order to prove that we're on the right side of the balance of the infringement of employee privacy rights, we're going to have to show evidence of a problem, right? And it's not going to be enough to say, well, we're complying with a global policy. That's the reason. That's not going to be a sufficient reason to overcome this balancing between employees' rights of privacy. And it's like bodily privacy here, right? You're being patted down. So it's going to be pretty high. So just saying, well, we've been told to do so by, corporate isn't going to be enough. And as someone mentions, there's no evidence here that we have a problem locally. And so it's going to be very challenging to go to an arbitrator and say, well, they have this problem in France, so we want to stay on top of it. Right? Now, one thing you could argue is best practice, industry best practice. But once again, if you're not able to demonstrate a problem that the policy is meant to address, it's going to be very difficult. Okay, so let's look at best practice. So the main thing you want to do when you have to introduce a new policy is get ahead of the grievance, right? Think about what the union is going to be alleging. They're going to allege, oh, it's invasion of privacy, it's a human rights violation, whatever the context is they're going to raise. Try and identify that in advance, and then you can start building a record, right? You can document internal problems. Maybe it's a health and safety concern, right? That show that an intervention is necessary and it's reasonable. You can collect data internally on the problem, or you can look at external comparators, so industry best practice. You can hire experts. So there's occupational health and safety experts that can give advice on what's normal in the industry or what's needed in your particular plant or facility. And the other piece is you can consult with the union. It will definitely help with the argument that you're being reasonable to say, hey, we brought this to the union and they identified these 5 issues. Well, their first issue was that we shouldn't do it at all. So we couldn't really listen to that one, but we could listen to, the 2 second and third recommendation they made. And we tweaked the policy and changed it. An arbitrator will really like to see that, and it will show that it was introduced in a reasonable fashion. And then you want to really be careful and scrutinize it. So you're not drafting in a way that's contrary to the CBA, the collective agreement, or the law in some way. Because there may be nuanced ways that the union could argue that the policy is contradicting the terms of the collective agreement, and then you're going to lose the case. So that's another reason to consult the union in advance, is you get a little bit of a warning on what their argument's going to be. And then you want to run training with employees on the policy before it's put into place. That's pretty standard. So before we go on to this topic, there was a question in the chat about to what extent does KVP apply to non-unionized workplaces? And it's just a big 0, not applicable whatsoever. And employers have broad reign to introduce policies in non-unionized environment. They don't have the same reasonableness requirement. There'd only be 2 restrictions off the top of my head in a non-union environment. One would be you need to comply with statute, so it couldn't otherwise be contrary to statute, like human rights law or the ESA. And 2, it could be a constructive dismissal. So if you introduced it could be. I mean, if you do something so massive, like that changed, like everyone who's working remote immediately has to work in office starting tomorrow, even though they've always worked remote. But that's a policy change. And for a lot of people, they could allege constructive dismissal for something like that. So you still have some restrictions, but they're not the same. They're not fleshed out the same way. Hope that helps. Okay, this is a fun topic, the risks of dealing directly with unionized employees. So across the board, courts, labor boards, arbitrators, they've all held that once a union is certified to become the bargaining agent for the employees, they're the sole representative, an exclusive representative for employees. You can't bargain specifically with employees anymore or make any deals with them. So that means past agreements between the employer and individual employees, they're kind of put in limbo. I mean, some people would argue that they're just dead. I would say that some parts of them are still alive post-employment. So if you had, say, a confidentiality agreement in an individual employment contract, it would be in limbo, like paused during the term of employment when the person was unionized. But once they leave employment, it might kick in again, for example. But generally, you're not going to be able to rely on any of those terms specifically during the course of employment. And any agreements you make directly with employees are not going to be enforceable. And the level of that even goes to the point that grievances are not the employee's grievances. We often say, "Oh, this is Jan Smith's grievance," but it's not. It's always the union's grievance, and unions can settle them unilaterally. They don't even need the griever to sign off on the grievance because it's theirs. So that just emphasizes how singular the relationship is between the union and the employer. The employees aren't really involved directly. Okay, so let's look at some fun cases. This one was personally not fun for me. If you ever look this case up, you will see a young Russell Groves as a summer student helping out a very senior lawyer on this case. And we went down in flames. I took some of the blame, but it's kind of an interesting case. So the griever, when he was hired by this company, told the company that because of his religious beliefs, he didn't want to be participating in the company's RSP program. His religion didn't allow him to participate in anything where he could collect interest or usury. So the RSP was an investment. He didn't want anything to do with it. The employer had several meetings with him to try and encourage him to sign up, the benefits, etc. But they also realized they had a duty to accommodate him and in his religious belief. And so they eventually just dropped it after, asking him numerous times. The group RSP was part of the collective agreement. So the employee, the griever, he worked for 10 years, no problem, wasn't participating in the RSP, but it never really came to anyone's attention. And then he ended up leaving through some complicated situation, but it wasn't relevant. And during his exit, he met with the union, and the union was getting his package together. Like, okay, you got this, you got this. Have they paid out your RSP? He's like, oh, I didn't want that. And I'm like, oh, you can't. What do you mean you didn't want that? Like, you're going to get it. And so the employee, it wasn't clear if the employee was on board with this, but the union grieved the company's refusal or failure to assign this griever up to the RSP program. Look at the next slide. And Arbitrator Brownlee refused to accept the employer's argument that the union should be prevented from relying on its strict rights in the collective agreement because this employee made this personal agreement with the employer. And the reason she refused to enforce that was because that employee didn't have any authority to monitor, to change the terms of the collective agreement, which is basically what he was doing when he made that agreement. The employer also argued that, well, there's no proof that if the union had been involved, it would be any different outcome. She ignored that argument as well, and the grievance was allowed. So even in this case where there was a very clear agreement that the employee didn't want to participate in a benefit, the arbitrator still found that the employee and the employer couldn't make that agreement. And so the collective agreement was breached, and the griever was owed damages for failure to participate in the program for all that time. I think it was around like $15,000. It wasn't a ton of money, but so the next case we had to confidentialize because of some client connection to it. But the employer in this case introduced a recognition program where employees could be recognized by their managers and provided with awards of not monetary awards, but things like a jacket or a camera or, things like that, gift certificates. And the union grieved that as well, alleging that it was the exclusive agent for employees with respect to compensation. And this was basically going around them. And also, it was differentiating within classes on the wage grid in terms of remuneration based on performance, which is something that obviously is not allowed in unionized environments. The employer tried to argue that it wasn't an actual term and condition of employment. It was just sort of ancillary on the side, but the arbitrator didn't buy that. So look at the next slide. And found that it was a form of compensation, and the the differentiating between employees based on performance was contrary to that concept, that employees in the same classification should receive the same remuneration. So that can be contrasted with this Canada Post case that I mentioned here, which is funny. And then the one there's two cases actually, two Canada Post cases that are quite funny. So this other case, Canada Post case, Canada Post basically broke up its one of its distribution centers into teams and assigned team performance goals. It might have been down to attendance actually, so attendance goals. And a team that really achieved this attendance goal would get a certain amount of money that they could allocate to a charity of their choice. So they weren't actually personally benefiting from it. And that was actually upheld because it wasn't a form of compensation that was conflicting with the union's exclusive rights in the collective agreement. So there are ways to do this. It's just you have to be careful. There's not an overlap with a right within the collective agreement. And the funnier Canada Post case that I saw when I was just reviewing this was there was a manager at one of the distribution centers who decided to, just on his own, hide Easter eggs all over the distribution center. And if an employee found it, they could bring the Easter egg in and get a gift certificate in exchange. And it was just meant to be like a fun Easter activity, which of course the union had to poo-poo and big grievance for. And the grievance I thought was hilarious and infuriating. So they agreed, first of all, that it was a compensation. And that was discriminatory because it was based on religious practice, Easter, and also that employees that were out of the workplace because of disability were being discriminated against because they couldn't also go on this Easter egg hunt. So the arbitrator sort of stomped on that. Arbitrator Swan stomped all over all of that, actually, which is nice to see. So first of all, he found that like the hiding of Easter eggs is like basically no connection to religion. It's not really part of a religious practice. Found that it's obvious that employees who can't attend work because of a disability are often in a detrimental position to engaging with workplace activities. This was not new or different from just the normal detriment that they experience. And then he also found that because it was a one-off thing and it wasn't tied to performance in the workplace at all, it wasn't actually compensation. So it was very different from this case that we looked at with the employee recognition, where people were being rewarded with prizes specifically for workplace performance. Great. So just in summary, dealing directly with unionized employees, don't do it. Just don't do it. There's very narrow exceptions. So sort of the routine application or administration of the collective agreement, like scheduling a vacation, implementation of policies that don't overlap with rights in the collective agreement, you can do that, right? If they do, then you've got to go the KVP route or negotiate with the union. But otherwise, you have to be very careful about dealing directly with employees on any topic because it's not going to be enforceable. So you can make a deal with an employee and the union can step in and basically pull the rug out from underneath you. Right. I'll turn it over to Emily, and then while Emily's going over bargaining updates, I'm going to look at the questions and we can try and answer some of them.
Yeah, perfect. Thanks, Russ. So as we set out at the beginning of the webinar today, we do this every so often just to check in on what is happening at the bargaining table. All of this is Ontario based and it is sourced from Collective Bargaining Ontario. So if you're interested in learning more about what we're talking about today, you can go online and check it out. They have a bunch of interactive graphs, which we'll go through today. So moving to the first slide. So we always, or at least in recent history, have started off with this graph just because as the data builds, you can kind of see a broader trend across the years when it comes to wages. And so this is a chart of the increase in wages from 2018 to 2025 across four different sectors. So the provincial sector is the blue. The municipal sector is the dark gray, the federal sector is the purple, and then the private sector is I'm going to go with gold. But what's interesting about this is you can see the graph almost bifurcates around the 2021-2022 mark. So if we're looking between 2018 and 2021, you can see that, wage increases are on the lower side. So dancing around that 1% to 2% range. And they're also not too, the industries aren't too different from one another. So they're kind of moving along relatively in tandem, obviously with slight differences. But then in 2022, we obviously, the private sector shoot up past all of the other sectors. And then kind of trailing that in 2023, we have the provincial sector shooting up again as well. And it comparatively speaking to the last few years, the wage increases themselves have been a lot higher. There's been a lot of conversations over cost of groceries, cost of eggs. So again, this is not very surprising, but it is interesting to see that kind of trigger point between 2021 and 2022, right at the end of the pandemic, depending on when you're counting. So we can move to the next slide. So looking at this, what this is a chart comparing the consumer price index with average wage increases across the different months in 2025. And what's interesting about this, I think, is you can see wage increases in both the private and public sector, private being again gold and public being blue. Is steadily outpacing the consumer price index. What I think is interesting is right around August of 2025, you can see that not only is it outpacing the consumer price index, but it's outpacing it by a fair amount. So I think that goes to show the conversations around the increase in the CPI are still having an impact on decisions at the bargaining table, even if CPI itself isn't increasing at a too aggressive of a rate. So again, seeing like those priorities play out in data is interesting to note. So next slide. What we're looking at here is this is a breakdown of wage increases by industry in 2025. So the winner is the construction industry with an average wage increase of 5.7%. And then kind of trailing behind is the primary industry. So it's things like coal and farming at 3%. That being said, other than kind of the outliers at the higher end being construction and then the transportation, communications, and utilities industry, most other industries are fluctuating around that 3 to 4%. Again, staying pretty steady throughout as compared in 2025. Next slide. Okay, so this is another interesting data point we've kind of watched year over year. So the question being, how are we reaching agreements with the union in 2025? Because this can differ year over year. So if we're looking at 2025 so far, you can see that the vast majority of settlements were reached through arbitration. So almost 60% there. Parties have needed that kind of third party to weigh in and help get a deal. Whereas you can see that something like direct bargaining, so the parties are working things out themselves, that's floating right around 18%. So that's a significantly lower number of parties that are able to reach an agreement with a union without the assistance of that third party. And then fortunately, you can see that settlements following a work disruption, so a strike, are only at 2% for 2025. So things have been relatively quiet from that perspective, with things, yes, reaching to the point where they need arbitration and that assistance, but not going so far as to actually, walk out. So we can move to the next slide. And so this, what we're looking at here is how long negotiations lasted in 2025. So how quickly can the union and the employer sit down and work out what the contents of the collective agreement are going to look like. So this is broken up between the public sector, which is the bar on top, and then the private sector, which is the bar on the bottom. So if we're looking at the public sector, we can see that right around 50% of negotiations lasted more than 12 months. So that is a long time, certainly as compared to the private sector, where we can see that about 65% of negotiations only lasted 1 to 3 months. So definitely a stark difference between the public and the private sector in terms of how long those negotiations have taken, or the majority of those negotiations have taken. Next slide. And then this is another chart we often include, again, just because as the data builds, we can see more of a pattern year over year. So when we're speaking about work disruptions, we're speaking about strikes. So we can see that the outlier remains in 2020, where there were, a significant number of public sector strikes. And whereas things have remained, relatively stable um, leading up to 2020 and then following 2020, particularly in the public sector. And if we look all the way to the right at 2025, we can see that historically speaking, this is on the much, much lower end of work disruptions since 2014. And in previous years. So we are, I think, yearning for precedented times. So it is nice to see that there have been less disruptions this year and less things to tackle from that perspective. And then this is a very similar chart. Again, this is just a visualization of the work disruptions uh, as compared between 2020 all the way up to 2025, with a big spike in 2020, things staying relatively stable over the next few years, and again in 2025, things are quiet, at least from that perspective.
Emily, do you have any predictions for 2026? Any thoughts?
I have hopes. Do you?
Because, well, I mean, I think the effect of tariffs is going to be the big question mark on the Canadian economy. It seems like the economy has sort of defied expectations with at least job numbers most recently. But generally, when the economy starts tightening, there can be unique pressures put on bargaining. Right? Employees are more fearful about closures and long strikes because they might not have as much of a safety net of other jobs to go to, or their spouse's employment might have been affected. But also, employers are trying to batten down the hatches a bit. So it seems to me that employers have spent some time already sort of ahead of this, trying to cut costs. We definitely seen that. I've seen that in my practice. This has been a year of reductions largely. I think battening down the hatches. So I think it is going to depend on, how tariffs bite next year. And it's probably going to be very industry specific. Great. Okay. So we had a few questions in the Q&A, which I thought were great. So maybe we'll go through them. We're a little ahead of time. Maybe we can, let you guys leave a little sooner too. Okay. So first question is, can you comment on annual updates to written corporate policies that are part of the regular cycle of review? So this would be in regards to KVP. And particularly the question is, what sort of documentation is necessary to justify those updates, and especially when they're minor changes. So I think one thing to keep in mind is the union doesn't always have an argument, right? When we talk about reasonableness, we're balancing those scales. Sometimes the union will have lots to throw on their side of the scale, privacy or human rights or what have you, right? Sometimes they just won't have anything, and we'll have all the balance. So we will have the right to implement policies as long as they're just reasonable. So you could introduce a policy around vacation scheduling, and as long as it's fair, it's reasonable, and it doesn't violate anything in the collective agreement, there doesn't need to be a big, background on like, why are we doing this? You don't need to have a huge explanation. So I think from the day-to-day stuff, you don't need to worry about it as much. It's the bigger changes that are going to, connect with some of those issues around privacy and human rights that are really gonna where you should stop and think a bit before you implement in terms of building a record. So I wouldn't worry too much about sort of the day-to-day policy reviews that you're doing and updates. It's really going to be where there's significant changes that push the union to say, well, like Hold on. I hope that answers the question. The next one is if the employee has a human rights objection to the RSP, does it not overrule the CA? So this is to do with bargaining directly with employees and the example we had in the TORCAD case. So yes, it's an interesting question. Arbitrators have found that human rights legislation is quasi-constitutional. So if we're going to look at like a hierarchy of laws, you've got like constitutional law, which doesn't really affect most public sector employers. Then you have human rights legislation, and then you'd have other types of legislation, I suppose, and then you'd have the agreements of the parties, so contracts. So that would be a hierarchy generally. And so, yeah, human rights law could trump it, and that's why unions are required to, for example, waive seniority requirements in a collective agreement as part of the duty to accommodate. Arbitrators have consistently held that a union can't say, well, you can't offer accommodation by giving this person who's disabled or needs childcare limitations or has childcare limitations this shift because they don't have seniority for it. Unions can't say that because the human rights law trumps the collective agreement. But so in this case, though, I think the employee was not asserting that anymore. Like it wasn't about, and it goes, I think, to the core of the question. It wasn't about the employee's wishes. It was more about the union's right to enforce the collective agreement. So I think if the employee had said, no, I don't want this money, the union probably wouldn't even aggrieved it. And we probably could have said that, yeah, we can't pay this as a form of accommodation. Or, maybe the arbitrator would have thought, okay, you can have like the base amount, but not the interest amount, which I think is one of the recommendations of arbitrator Brownlee in that case was like, well, you didn't have to sign them up for the RSP program, but you could have done something like put the money just in a bank account that didn't collect interest for them. Like you didn't have to like totally cut them out of the program. So I think it probably just the way the case played out, but it's a really great point about the human rights piece. Um, I probably should have thought of that as a young summer student. Um, okay, let's see. Oh, this was an interesting one. So what about settlements at the HRTO? And I think the point is when you're dealing directly with an employee, they might bring a complaint to the HRTO and not a grievance, right? And so it's outside of the grievance process. And usually that's not allowed. Courts have been very clear that you can't go to civil litigation when you have a unionized workplace because you've got the collective agreement and it's in place and it's meant to resolve all workplace disputes. But the Human Rights Tribunal, at least in Ontario, has said, actually, we'll let you bring a HRTO complaint here, even if an arbitrator has jurisdiction to your human rights complaints. It's pretty frustrating, and it's even gotten worse recently, where the HRTO has been saying, we'll even hear cases in parallel sometimes if the issue isn't directly overlapping. So that it is a situation that could come up where you enter into minutes of settlement with an employee, um, and those could be in conflict with the collective agreement. That would be, I think, very dangerous. It would be one thing if the HRTO made an order. I think both parties would likely have to comply with it. And I think in that case, you'd want to name the union as an intervener and get them involved in the case. But if you just settled a case directly with a complainant to the Human Rights Tribunal and it involves some change to workplace terms and conditions, like the employee got their preferred shift or what have you, I would be very worried that the union would grieve that because it would be a side deal that's not enforceable. So, yeah, really great point. Here's one. If a recognition program applies to all employees, not just unionized ones, would that still be the same risk of dealing with employees directly? Yeah, it would. I don't think there would be any distinction on that. An arbitrator wouldn't care. It would still be trying to potentially seen as negotiating around the union, and I would be worried about that one. But once again, it's always going to depend on the facts. It's hard to answer these questions in isolation. Um, let's see this one. To what extent may an employer regulate employees' expression on political or geopolitical issues such as Palestine and Israel within the workplace? And how should any policy be interpreted in light of the collective agreement, including where the agreement is silent on political expression? So I think that's a good one. I think there are cases out there about expression outside the workplace, and how that can potentially put the employer in a negative light with the public. So if someone makes a comment, say on the news, and they're identified as an employee of a certain company, that can damage the reputation of the company, and the employer is able to take action on that front. And so I think you could have the same sort of policy here in a unionized workplace internally, where political statements are not allowed. You'd have to be really careful that it would be not targeting one type of political statement. You'd have to make it very general. And then the union could grieve it and say that you're infringing on some right to freedom of expression in the workplace. I don't know how developed that is. I suspect there isn't a huge right of freedom of expression in the workplace, but we'd have to do some research on that. And then it would be just a weighing of, why is the employer introducing that policy? Has there been just arguments? Has it caused disruption? Have there been a whole bunch of workplace harassment complaints because of some sort of political expression in the workplace? Um, and if so, the employer might have a good argument to say, well, the union might say there's some right to freedom of expression, and the arbitrator is going to decide which one is more important. Thanks for joining us. Happy holidays to everyone. Hope you all survive the pre-holiday rush. I know Emily and I are quite busy right now, it was just what we're here for. It's all good, but it's a lot. I'm sure you're all feeling the same thing. So thanks for sharing some time. I know it's very precious this time of year.